Hey there, legal warriors. In this video, I'm going to cover 3 important tips if you want to use video in your restraining order or protection order hearing in Washington State. It's a big problem. So many people involved in these cases have video or audio they want to use, and so often they don't get to use it. So in this video, I'm going to cover some tips you need to know to improve your chances of getting your case heard in the way you want in your very important court date. Stay tuned. This is a very important video for you. My name is Attorney Lance Fryrear. I'm a defense attorney in Linwood, Washington. My law firm's been defending people charged with crimes all throughout Washington State for more than 20 years, and I'm putting out these videos to help educate the public. So if you find this useful, please like it, please subscribe. More people get to see it. More people get the help they need. Now, as always, I'm just going to jump right into it. You just heard me say we're a criminal defense law firm. Well, really, we also do a whole ton of restraining orders. Now, in Washington State, the technical term is protection orders, but the Google universe likes the term restraining order, so I use that here. And there's a single law in Washington State that covers restraining order hearings, RCW 7.105. And if you look really deep into that law, and I don't expect you to, most lawyers don't even, I always carry the law with me in court, it's so complicated. It says restraining order hearings are special proceedings. What that sort of means is that the normal rules of evidence don't really apply. You don't need to authenticate videos in the same way. Hearsay is admissible. So all the stuff you see on TV, criminal court rules and fighting about evidence, it's not quite true, but almost true that pretty much anything goes in a restraining order hearing. And what you also might need to know about restraining order hearings is there's far too many of them, right? This is a newer law. The legislature made some big mistakes, in my opinion. And they made it so the whole system is overwhelmed with everybody wanting to restrain everybody. And so it's a big problem for the court system. And what that means is the court system wants to speed these things up, right? The court system doesn't want to watch your video. The court system will make all types of reasons why they can't. I'm so impressed that the court system is even surviving at all because I'm directly involved in multi-hour hearings multiple times a week. Me as the owner of this big law firm, it's one of the only things that I still personally do for the most part. We still handle some crimes, I do, but it's mainly this order, so I see it every week. So tips about how to get your video in the evidence. Well, the first tip and most important tip is contact the court. Court is going to have a unique instruction for you, and sadly not always correct, about how it is that each court is going to either allow or not allow video to be used. And what do I mean, contact the court? Well, you can call on the phone, right? You may or may not get through to a human. I would probably go in person if I had the chance. Like, let's say Snohomish County Superior Court, right? King County Superior Court, Pierce County Superior Court. When you go into those courts, they're big enough that they're going to have protection order offices where they're designed to tell you how to do things, either as a petitioner, mainly they support the petitioners, but also the respondents. For example, Snohomish County is going to have some sheets on the wall that tell you can pick them up and it's going to tell you how to do it. You can also search websites, but I don't trust them as much, okay? I don't trust them as much because, things change, and if a court changes its policy, they don't know how to get a hold of their web guy or web gal to get that changed, right? That's the last thing they think about, right? And when you're down at the court, you get your one chance at court. Well, the website said this. Well, that's not how we do it. You're not using it. And they don't want to use it because they got 15 other cases they got to get to, right? So one is simply ask the court, pay attention, and then try to follow what they say. General tip number 2 is I want you to have your own device available to be able to show the video in court yourself. And I want you, in most cases, it doesn't mean they're going to do it this way. These are just tips, right? Have 2 copies of whatever you want to show on a zip drive that you can plug into your own device. You're probably going to need 3 copies, actually. 1 for your own device, 1 to file with the court, and 1 that you need to send to the other party at some point so they have it ahead of time. So if you tried to do that in King County Superior Court, they wouldn't let you because that's not how they do it. Right now, when I'm filming this in September of 2024. I think I remember what day it is a little bit. So in King County, currently in September of 2024, what we've had to do, and this is not legal advice for you, I'm telling you this is why it's different, and I need you to like figure it out, how so you can get your video used, is there we've got to get a hold of a clerk by email and get a share file link, and I got to upload the share file link, and I got to upload it, and I don't get to show it in court. Right now in September 2024, in King County Superior Court on these orders, the commissioners or judges will review the videos in chambers, and it never gets shown in court unless the commissioner or judge wants to. If you try to do that in Snohomish County Superior Court, there's no such system. In September 2024, you're going to have to like bring it and show it to them and beg to show it, and you may still not see it because there's such limited time in that court. Now, in district court, they do it even differently, right? We just got told one thing in King County District Court and one thing in Snohomish County District Court and a different thing in Pierce County District Court. So even for us attorneys, it's hard. So you might want to think in your head, do I really need to use the video? Or can I talk about the video in my filing, right? How important is it? That moves on to tip number 3. Courts have limited time. If court doesn't want to watch a video, they might tell you, why don't you take some screenshots of the video, file it as an attachment to what you're filing, and make a transcript of what it says, so maybe I don't have to watch it. So when we are doing filing a video, we're usually going to cover all the bases. We are not going to assume, even as experienced attorneys, that a very frantic, fluid, variable court calendar will be able to get something shown we want shown, right? So we will try to also, and this is what a tip would do, is try to reference the video in your filing, take some relevant screenshots in the filing in case the court doesn't want to see it, in case you don't get the right advice about how to see it, in case you don't get it to the other side so it can't be shown. You at least have some ability for the court to get your point, and the court in the back of its brain goes, well, there's a video, so maybe I should at least pay attention to this part if I'm not going to see it, right? I could go on and on and on about different tips, but I think I said 3 tips at the beginning of this, and so those are the 3 big ones that stick out, right? It's really important that you continue to check how it's used, and then think about, should I use it, right? Sometimes this video that you think supports you may not, right? Show it to someone else who's relevant. How does this seem? Plenty of times we are given videos by our clients, and we go, this is pointless, right? It doesn't show what you think it shows, and it can actually hurt your case. If you are claiming a video shows something that isn't relevant to the case or doesn't show what you think it shows, it just upsets the court. And the court's already mad, usually. They're mad that we're here, or they're mad at the situation. They're humans, they're worn out, they're exhausted, and you don't want to lose credibility. You want to make it as easy as possible for the court to see your point of view using as little energy as possible because they don't have much available given the demands on them from these protection orders. So what's the golden rule? Ask the court, do what they say. The second rule, make sure it actually helps you. Because so many times people are on the phone, it's like, I have proof. I got 5 videos. And we look at the 5 videos objectively, and it's nowhere near proof, right? We go, we're no way we're using those because you lose credibility. Sometimes we get the call, I have proof. You go, oh yeah, that's proof. That thing is gold. That's going to win the case. But if you're in it, you usually can't tell that yourself. So that's what I have to say. Hope you found this useful. If so, please like and please subscribe. More people get to see it. More people get the help they need. More importantly, if you had a criminal matter or a protection order, although we're really flooded with those, feel free to reach out to my firm. We get on board. We'll listen to what happened. We'll identify a way forward, and we will be there for you. Thank you.